want to introduce Joel Beus to you. He's the chief legal counsel here at Rev Road. He is married to a wonderful lady named Anya. They have 5 children together. And he served his mission in Russia, an LDS mission in Russia. So we like to refer to him as Comrade Joel. He has worked in commercial litigation in Dallas. He's been doing that for 12 years before coming out here and being our chief legal counsel. He is a graduate of BYU, so that's why we give him a pass. And he got his JD from Harvard. So we're going to bring up Joel right now, and he's going to take over and just wow us with intellectual property information.
Okay, it's on. Thank you. Thanks for that introduction, Jason. We'll talk about it later. I really appreciated that he shared that there's going to be a quiz later. That's the key point, and hopefully that will motivate you, because I'm aware that this legal information, while potentially important, is not going to be that entertaining, but there is a quiz and there are prizes associated with the quiz. Last year when I did this, I spoke about trademarks and protecting intellectual property in that way. Sometimes trademarks can be the most valuable portion of your intellectual property. Today we're going to talk about a topic that's a little bit less known in the area of IP. But before I get to that, Jason mentioned that I worked for 12 years in Dallas, always in law firms and always with lawyers. So it might not come as a surprise to you that lawyer jokes weren't a big thing, because it was all lawyers around, and we're not known for our sense of humor. But since I've come to work at Rev Road with non-lawyers as the only counsel here, only attorney, I've realized that lawyer jokes are a thing. And so I figure I should probably address that before we move on. The most mean-spirited joke that I've heard recently, I'll tell you right now, and if you don't laugh, I will appreciate it. But it is, what is the ideal weight of a lawyer? And the answer is about 3 pounds, including the urn. It's terrible. So mean, right? Anyway, so now that we've got that over with, we've addressed the elephant in the room, that there are jokes about lawyers, and I am a lawyer. There are 4 basic types of intellectual property. You're familiar with copyrights probably. They protect original works of literature, art, architecture, sometimes computer software. Trademarks protect your brand names, logos, catchphrases, anything that distinguishes your goods and services from those of your competitors. Patents, of course, protect inventions and designs. And this is my favorite example of a patent. It's the pet ear protector. So somebody got a patent on this thing that keeps your dog's ears out of its water and food when it's eating. So if you're inclined to be intimidated by the patent process, remember that somebody got a patent for that. And the 4th kind of intellectual property is a trade secret. It's a little bit different from the other 3, but it's becoming increasingly important, and that's what I want to talk about today for a few minutes with you. What is a trade secret? The definition varies from state to state somewhat, but it's defined both in federal and state statutes. You can look up the exact definition in Utah if you need. But generally, all of the definitions have in common the fact that it's information that's kept secret. It's not easily ascertainable by third parties on their own, and it has economic value independently by virtue of its confidential nature. Here's some of the examples of kinds of trade secrets, or things that qualify for trade secrets there at the bottom. It's a lot of things. It could be customer lists, marketing data, customer profiles that you've developed over the years. All of those could qualify as trade secrets and get special protection under the law. The trade secrets for a long time were not a great focus of the law, but in 2016, and lawsuits to protect trade secrets were always filed in state court, and there were a lot of complications, and it was hard to do. In 2016, though, Congress passed and President Obama signed into law the Defend Trade Secrets Act, which created a civil cause of action in federal court, and over time it should create more uniformity in trade secret law and should make it more predictable and should provide additional protection for companies seeking to protect their confidential information. Some famous trade secrets that most of you are probably aware of: the New York Times bestseller list. The methodology by which it compiles this list, it's a secret, no one knows exactly what it is, and it adds value to the New York Times. Coca-Cola never patented its recipe for original Coke. Instead, it's a trade secret. And it's been able to keep that confidential. Google, the way that it stores information and is able to produce unique search results for each user, that process is a trade secret. It's not been patented, it's not been disclosed. DuPont's Kevlar technology, by which it makes the aramid fibers that go into flak jackets, it decided not to patent it, kept it secret, so it's never been disclosed. And these are some interesting examples that kind of lead into the topic of advantages of trade secrets over patents. Sometimes a company has to make a decision. Do we want to protect this intellectual property, this information, with patent law or with trade secret law? Because there is some overlap there. Some benefits of trade secret protections over patent. To get trade secret protection, you don't have to disclose it. Of course, when you get a patent, you have to disclose it to the government. It becomes public knowledge if you obtain the patent in the end. And you may not want that. You may want to do what Coke did and just keep it a secret, so that you don't have any competition that way. The protection will last forever for trade secrets, theoretically, as long as you're able to maintain the confidentiality. And patent protections, of course, only last 14 or 20 years. No registration costs for trade secrets. You just maintain their secrecy. With a patent, we know that the costs are fairly high. Attorney costs, registration costs, fees with the government. Trade secret protections go into effect immediately. As soon as you identify what your trade secrets are and you start treating them as confidential and proprietary, patent process, the process of obtaining a patent can take years. Also, your information that you want to keep confidential may not qualify for a patent, but it might qualify as a trade secret. Something like a customer list, for example, would not be a potential patent, but it could be a trade secret for your company. Of course, there are downsides, and there are reasons to choose patent protections over trade secret protections. One is that patents afford much stronger, almost ironclad legal protection for your information, for your invention. If you have a trade secret, somebody else could develop the exact same invention and patent it, and even though you developed it earlier, they would be able to exclude you or your use of that invention. Once a trade secret is revealed, it's really hard to turn back the clock. It's probably going to be fair game, and that may not be desirable, and it's something that needs to be taken into account when you make that determination, the choice of what kind of protection you want to seek. There's no presumption of validity for a trade secret. If you go to court to protect a trade secret, you're going to have to establish to the court that all the measures that you've taken to keep it confidential, you have to show that it falls within the definition of a trade secret. If you have a patent, you just show the patent, and you have automatic protections already in place. And we've kind of already touched on the fact that it's much easier to lose a trade secret. If you send an email to the wrong person that includes confidential information that you didn't intend to disclose, it could be it. Very hard to lose a patent, certainly not in that way. I mentioned that the government recently has become more receptive to the idea of enhancing trade secret protections, and that's a good thing because over time, the risks of trade secret theft are increasing quite a bit with the proliferation of cell phones, mobile devices. You have the ability to store and transmit information, including confidential information. Every one of your employees has that, and that can become a real risk. There's a great job market. People are very mobile, and research has shown that 50 to 60% of employees, when they leave a job, they take confidential information or trade secret information with them to their next employer, and that could be a real risk for you as your employees leave. Anytime you have foreign business partners who may not have the same legal structure or legal protections in their country for trade secrets, or they may not have the same respect for U.S. law on trade secrets, that introduces some risk as well. And finally, if you have a large sales force that is privy to your trade secret information, and their job is to go out and sell and promote your goods and services, there's a risk of disclosure there. Another concern is if you hire somebody that comes to your company with trade secrets that they brought from somebody else, you may be opening yourself up to potential litigation from that previous employer. It's a good idea to include a disclaimer in an employment contract, or if you suspect that one of your employees has brought trade secrets or confidential information with them, you may want to initiate an internal investigation, potentially with a law firm, to cover your bases and help defend against any potential litigation. That could have come in handy here in this particular case study. You may have heard of Aubrey McClendon. He was a pioneer in the development of fracking technology. He was a founder and CEO of Chesapeake Energy. He was also instrumental in moving my favorite basketball team, the Seattle Supersonics, to Oklahoma City, which was a cause of some angst for me for a while, and then I just welcomed it and became an Oklahoma City Thunder fan. But he got crosswise with his board of directors in 2013. He was forced out. During the period before he left, he reportedly had his secretary print out 20 terabytes of data, which I'm told is a lot of data. And I can imagine some poor soul was trying to print out a 3-page memo while his secretary was printing out 20 terabytes of data, and they never saw that memo again. But he also emailed lots of trade secret and confidential information to himself, including some open acreage reports that Chesapeake had invested quite a bit of money into developing. When he left, he started his own company. He attracted lots of investors, and one of the first things they did was to purchase land that was in these open acreage reports. Chesapeake sued his new company, and they eventually settled confidentially. Of course, the details of the confidential settlement did not remain confidential, and we found out that they had to give up a large portion of that acreage, and they had to pay something on the order of $25 million. So it didn't turn out well for that new company because their CEO had brought these trade secrets with him, and it caused a lot of problems. So let's talk about some practical things that you can do to protect your trade secrets. Once you've identified what they are, once you've identified what your confidential information is that has value in being confidential. First of all, I mean, it's kind of self-evident, but restrict access. Not every employee needs to have access to all of your trade secrets, and you should consider whether there's a real business reason for your employees to have access to it. Introduce password protections to digital copies of it. Put it in a vault, put it in a safe. We'll talk about an example of that in a minute. Educate your employees. This might be maybe the most important one in our current environment where employees are so mobile. When you onboard them, talk about what your policy is with respect to trade secrets and what their legal and ethical obligations are with respect to them, and train them periodically during the period of their employment, and maybe most importantly, before they leave, remind them, okay, you had access to these trade secrets and this confidential information, and here's what your obligations are with respect to that. We're watching you, basically. Sign non-disclosure agreements with people that you need to disclose it to, anything that's confidential. All of these things will protect you, and they will support and buttress your claim if you ever have to go to court and assert a claim to protect your trade secrets. Mark documents as confidential or proprietary. Again, these are all self-evident. This shouldn't be considered legal advice, by the way, specific to any one company that's here present today. I have to issue that disclaimer. So, exactly. So, here's one concrete example of a company that has a really valuable trade secret and some of the measures that they've taken to protect it. The Colonel's recipe of herbs and spices. Colonel Sanders was a real person. He had a real recipe. It's kept in a safe, and they've taken some really interesting measures over the years. Some of these stories might be apocryphal, but they are interesting. Supposedly, they had to upgrade the security in the facility where they kept the safe, and when they moved the recipe, they took it in an armed convoy somewhere across the city. Supposedly, no two employees of KFC who know the recipe are allowed to travel together. I mean, it all seems kind of extreme, right? But you can see how they would have a really good story to tell if they have to go to court and say that guy has misappropriated our trade secrets, and here's what we've done to protect them over the years. It's a good story. The few employees who do know the recipe of the secret herbs and spices, they've signed non-disclosure agreements, and they actually, with third parties, they have two companies that blend part of the mixture together, and then the rest of it's blended by KFC itself. So I think that's a pretty strong, they have a strong case to make for their protection of trade secrets. Sometimes these extreme measures that companies take kind of add to the mystique and the cachet of their company and their products, and it can lead to attitudes like this one from the movie, So I Married an Axe Murderer.
Dad, how can you hate the Colonel?
Because he puts an addictive chemical in his chicken that makes you crave it fortnightly, smart arse!
Okay, we got the important part there. Mike Myers at first said, how can you hate the Colonel? Anyway, some of these extreme measures might actually add to the value of the trade secret, and that's kind of the point. One more example of trade secret violations that have been in the news was this brilliant engineer named Anthony Lewandowski, who Google hired to work on its self-driving car company and technology called Waymo. He decided he didn't want to just be a rank-and-file engineer. He wanted to start his own company, which is fine. It happens all the time. But when he left, he took 14,000 files that Waymo later claimed were trade secret and confidential. He started his own self-driving company called Automoto, which Uber acquired in 2016. When Google found out about it and Waymo, they sued Uber. Again, another settlement that was supposed to be confidential, I think, but we know the details of it. Uber ended up having to give Waymo and Google $254 million of its equity, and they ended up firing Lewandowski because he didn't cooperate to their satisfaction in defending the lawsuit by Waymo. So that's another example of something that really didn't turn out well, because he took trade secrets. He probably felt like he owned them to some extent because he helped develop them, but they belonged to Waymo, and Uber ended up acknowledging that in the end. So to recap what we've talked about today, it's important to consider what information you have, your company has, that's valuable because it's not widely known. Consider whether trade secret protections, whether putting measures in place is the way to go, or whether maybe a patent would be preferable. Consider restricting access like we talked about with passwords, or putting in a safe, not allowing every employee access to all the information that you have. Use non-disclosure agreements. Mark the materials confidential or proprietary, and maybe most key, educate your employees. Let them know what your policy is with respect to trade secrets. And when they leave, remind them of those ethical and legal obligations that they have. Okay, that's what I have. Any questions? Yeah.
Maybe this is too specific, but in our employment agreements with our team members, we have a confidentiality agreement just as part of their general employment agreement. Is it typical that something like that's sufficient to protect trade secrets, or are you saying by requiring them to sign agreements, we need to require them to sign an agreement specific to a trade agreement for which they have involvement?
I'm a little reluctant to not knowing the whole situation, but I would say that would be a very good measure to take. I don't know that it would be sufficient on its own to say that, look, we've got this confidentiality clause in our contract, therefore all of our trade secrets are protected. We've taken the appropriate measures, but I think that's a very sensible approach. Thank you.
I go on over here with Joel.
Hey, Seth.
The thing I was surprised by is it basically says that one of the requirements is it's something that can't really be discoverable by a third party. And as technology continues and increases, making it for instance, if I do some sort of analysis on Kevlar and figure out how it's done, does that mean that the legal ramifications and what I have to do to protect trade secrets changes as technology does, or is it a bit more static? Do you have any indication of how courts would react to new technology that would essentially uncover trade secrets?
Yeah, I mean, that's a good question. It's a real risk as technology becomes more available, that a third party, by completely legal and lawful means, could come to the same invention or could develop the same information that you have. And and it's a risk. That doesn't mean necessarily that it's not a trade secret, but if somebody develops it independently on their own, there's not much that you can do with trade secret law to prevent them from continuing with that and exploiting that invention. Does that answer your question? Thank you, Seth. Braden.
Thanks, Joel. My question is, I'm sure a lot of us here are startups, and so this has been awesome advice. My question is, what would be the practical way to implement this? I know the answer is as soon as possible, but we're all, small teams, probably just a team of founders. What's the best way to start implementing this sort of thing where, hey, we're all going to work on this really super secret algorithm, so we should all sign this NDA? Or what would be your thoughts or advice on that?
Yeah, I think that would make sense to talk about it and sign the NDA. First of all, identify what it is. The more specific you can be about what's your secret sauce, what is information that would be protected by trade secret law, identify it, define it exactly, and then an NDA, is definitely one very, very sensible approach to take. It could be included in a founder's agreement, probably. Yes, sir.
In addition to a confidentiality agreement, a lot of people in this room hire software developers, and I think it's important that they understand the importance of having an inventions agreement as well, which would have solved a lot of the problem in the last case. So can you comment a little bit about that?
No, I mean, I don't know that I need to add much to that. That's a critical thing to put when you have a relationship with a contractor. It has to be set out who owns the IP that this contractor develops for the company, and that should be owned by the company.
Yeah, and a lot of people may not know what it is, but it's also important to have it with actual employees. The last company I was in, they've been in business for 8-10 years. Nobody had ever signed an inventions agreement, and we ended up having disputes with people over who owned what. So it's just, from the beginning, a great thing to have in place.
Absolutely. Yeah, definitely. Thank you for that comment. Very helpful. Anything else? All right. I'll turn it back to Jason. Are you coming up, or are we?
I am. All right, everybody.
We have another question.
Another question. Hold on.
Oh, good.
I went through a lawsuit on, this is exactly what you're talking about. So anyway, my point of the matter is that you have to be really, really careful to make sure everything's protected. Now, for instance, I found a manual from a company, and I just searched like marketing manual or marketing, and I just did a search, and it showed up, and it was unprotected. Okay, but if anybody can find anything, like in the lawsuit that we had that got part of our claims thrown out, was the fact that one of my claims, I didn't really talk about it necessarily, but I alluded to it in a speech or talk that was at BYU. And it was in a marketing class. Anyway, the point of the matter is that just that one little, you got to be really careful about anything you say, because if they can extrapolate, you'll lose.
Yep. It's really easy to inadvertently make a comment or send an email to the wrong person or neglect to have a non-disclosure agreement signed with some party, and you could lose your trade secret protections. It's serious. Yes, sir.
It's also trivial to make sure that every document you have has in the footer a statement that it's a confidential and proprietary document.
Yeah, I think that's a really good approach to take. Absolutely. Yeah, he said it's important to make sure that documents that you would consider confidential, that they're marked confidential or proprietary. Sometimes there's even a sentence in all caps that the companies will include, but all of those are things that designate trade secrets and will help to buttress your case if you have to go to court and prove that you've kept them secret, confidential. Yes, sir. I appreciate the Seahawks shirt, so I'll really do my best to answer
I
the
cried
question.
a little over the Sonics as well.
Yeah, that was a tough one.
Does putting that line on every single email and every single thing actually protect it, or is it just because it's on everything and we're talking about going to lunch today, suddenly it kind of trivializes it, and then when you get to a lawsuit, does it make it so that doesn't hold enough weight?
Yeah, I think that's a good point. I don't know of any specific instances, but I would imagine that if your case, if you go to court and you say, look, this is our trade secret information that they have breached, they have unlawfully used and obtained, and then they could respond by saying, well, they put this watermark on everything, or this footer on every email, even about going to lunch. I think that would dilute your argument. It would weaken your argument somewhat, which is why it's important to identify exactly what your trade secrets are and then make sure that those are the things that you're protecting. Very good question. You also see those disclaimers a lot at the bottom of lawyer emails that this contains attorney-client privilege, and that's another topic, of course. But. Oh, one more. June.
I have a quick question. So I know there's a lot of startups that outsource their development nowadays. What are some of the extra steps that we can take to protect it better, from people working from different countries,
Yeah, this gentleman here had a great suggestion to start out. Make sure that your contract has a prior inventions or inventions assignment agreement that clearly states that your company is going to own the IP that's developed by virtue of this contract. That's the main thing. And just so that they know and you know who owns the work product, who owns the IP that comes out of it. And we can talk about that more if you want. All right, thank you very much. Appreciate it.
All right, thank you, Joel. So, ladies, that is Joel Beus. He's a very valued member of the Rev Road team here, and that's the type of service and support that you can get when you partner with Rev Road. And we're just really grateful that he came here and is working with us, and is just a fount of legal knowledge.